name is Lulanga Sydney. I'm a tutor for Labor Relations 3. The code for Labor Relations 3 is LR20D3. In this course, we'll look at a number of factors, but first we need to realize the learning outcomes or the competencies that we'll be able to attain at the end of this course. At the end of this course, we are expected to be able to discuss the rights and obligations of both parties to the employment relationship, employers and employees. We should be able to understand what are the rights and obligations of each party. We should also be able to explain dismissals on operational requirements and those on misconduct. We should also be able to discuss the various reasons an employer may terminate the contract of employment of an employee. We need to understand the terms correctly: who is an employee, who is an employer, and what is employment. Between an employee and an employer, there's a certain agreement that one will provide the services, the other one will provide the payment upon satisfaction of the product that the employee produces. So an employee is engaged, an employer engages an employee. It could be based, it's mostly based on a contract. It could be verbal, it could be non-verbal. Non-verbal, mostly we are talking about psychological contract. And then if it's a psychological contract, an employee at the end of the day will not get a salary, will get wages. It could also be written, but it's a short-term contract. A day laborer, for example, weekly employee will not get a salary but will get a wage. The other learning outcomes, the competencies that we expect at the end of it is that we should be able to implement the requirements of a fair dismissal. We should be able to discuss the roles, purpose, and procedures in the employment relationships, and we should be able to explain the considerations regarding changes to employment conditions. So let's start with the employment relationship as a source of rights and obligations. There is an understanding between an employee and an employer. An employer is interested in the services that is provided or services that are provided by the employee. The employee is interested in the remuneration or compensation for providing those services. A contract has rights and obligations. So each party has certain rights and certain obligations, and the other one the same. And therefore, each one of them should fulfill those rights and obligations in order to attain or to achieve the common goal. So employees and employers, they have a contract that creates a reciprocal relationship. Each one has certain interests to be fulfilled, and each party has rights and obligations to the other, and the rights are explicitly stated. They are retained in pieces of registration, and in Namibia, for example, we'll be looking at the Labor Act of 2007. That's where the rights are stated for the employees. So contracts, as we have mentioned already, could be in writing or could be verbal. A contract of employment, there has to be an offer, and once that offer is accepted, the employee appends his or her signature to it, and the employer also appends his or her signature to it. Both parties are bound by that contract. And where there's an unwritten contract, minimum conditions are inferred for the behavior of the parties. So if, for example, I drive downtown or at the traffic lights, I pick one of those people waiting for a day job. I engage the person. We agree from the beginning the amount of money I'm supposed to pay them, and the casual worker, for example, will understand what is expected to be done and what they will get at the end of the day. So that agreement is there, it's unwritten, and both of us need to abide by that understanding. There's some first and rule that where there is employment relationship, there must be a contract of employment, written or unwritten. Unwritten is mostly psychological contract. Contracts are never static. They are ever changing, they are amended, they are altered, and therefore employees and employers need to understand that very well. For example, you may have a written contract with an employee and you ask an employee to do something extra and you promise to pay extra. At the end of the day, you cannot refer to the written contract to say where is it written, but you refer to the agreement that you had made verbally. So that is also abides. Now, what about an employee misconduct, discipline, and dismissal? The management of conduct and level of employee performance gives rise to most disagreements. An employee may misbehave. For example, an employee may not report for work, may refuse to take lawful instructions, may become violent, may not be performing as required, and this type of employee there is a requirement for discipline, and disciplinary measures that are put in place should be exhausted before the employee is dismissed. So we need to follow rules which are reasonable in order to meet the requirement to manage conduct and performance. Reasonable should be emphasized because reasonable means that the rules, those rules can be applied in to different persons in different environment, or change of rules or change of roles. An employer can also feel comfortable if the same rules were used upon him or her. So it's an employer's common law right to ensure employees adhere to reasonable standards of conduct and efficiency. Now, this area has potential for disagreement and discord between the two parties. So the employer has to ensure that the employees adhere to reasonable standards of conduct and efficiency. Now, this should not be open to different interpretations. It can only be open to different interpretations if there was no proper arrangement or proper agreement from the beginning. So rules of the game or workplaces should be explained at the initial stages of engaging the employee. Employees may sign contracts that they do not fully understand the content. So it's the obligation of the employer to explain what is in the contract, and if not, an employee can seek advice elsewhere to understand the content of the contract. Conflict may also come up, but it can be minimized by handling disciplinary procedurally. It means that the rules and laws that are laid down, the policies that are laid down, the Labor Act be referred to, and you follow procedure. And then we also need to note that issues of discipline, most contested frontier of employment relationship. Discipline is one of the contentious issues because an employee is not a child of the employer, and therefore sometimes employees tend to look at employees as their slaves or their own children, and the employees may be resisting that. It may be a bone of contention. Many employees never face a strike, will never face a strike, but they may have their dismissal problem challenged. For example, if you dismiss an employee unfairly, the employee can go to the labor commissioner, or you may force the employee, you may create a situation where an employee is forced to resign, constructive resignation. An employee may still take you to labor even if the employee resigned. So that can be challenged. Dismissals, the purpose of discipline is to correct, not to punish. And therefore, we need to look at issues of discipline in order to put in corrective measures. And then the purpose of sanction in society is mostly demonstration. So the code of practice states that dismissal in most serious it's a most serious step an employer can take, and it means that the employer has no other choice but to put into effect dismissal. And therefore dismissal should be the last resort, where the relationship of between employer and employee has reached a stage where it cannot be repaired. What are the alternatives to dismissal? Sanctions can be given, but these could differ in how serious the case is. You can give a warning, verbal warning, written warning. You can have about 3 warnings given to the employee before you reach the stage of dismissal. You can have counseling. So the entire process needs to be exhausted, except in cases where the case is so serious that the employee needs to be dismissed with immediate effect. You can also suspend the employee without pay, suspension without pay. You can also transfer the employee or demote the employee. So dismissal should be the last resort. Now, what is the definition of dismissal? Dismissal literally means that the relationship between employer and employee cannot be repaired, and therefore the contract should be terminated with or without notice. For example, an employee who just absents himself from work for a large number of days without proper explanation. An employee who refuses to take lawful instructions. An employee who becomes a danger to himself and also a danger to the organization. An employee who terrorizes the employer. Employees expect employers to renew fixed-term contract on same or similar terms, but employers may offer to renew it on less favorable terms or never renew it. So the contract is terminated there. The refusal by an employer to retain employee after maternity leave could also be dismissal. But we need to always refer to the Labor Act and the company policies to understand what are the rights and obligations of both employee and employer. A number of employees are dismissed on same or similar reasons, and employers have re-employed some or one but refused to employ the other. So it could also be interpreted that way. Employee can also terminate the contract because the employer made the conditions unbearable. Now, unfair dismissals. Dismissals are said to be never fair. So a dismissal is said not to be fair if it happens by breaching the contract. Automatically unfair because it goes against the law. For example, dismissing an employee for joining workplace forum, participating in a legal strike, an employee refusing to do work of an employee who is on strike. So we can look at that, and you can also give more examples related to that. Now, what it means is that if an employee joins a union, for example, an employer, so long it's a legal forum, an employer cannot dismiss an employee for that. If the strike is legal and an employee participates, an employer has no right to dismiss the employee. And if the other employee is on strike and then this employee is asked to do the work of the other employee and refuses, you cannot dismiss that employee. Now, what about dismissals based on disciplinary reasons? For example, code of conduct. An employee does not observe the code of conduct. There are rules laid down, the employee just decides to behave otherwise. Employee can be dismissed. Elements of procedure fairness in terms of terminations, if they are followed, the contract may be terminated. In form of misconduct, an employee can be dismissed. If the fair hearing has been exhausted and the employee is still found wanting, the employee can be dismissed. There are some common forms of misconduct which the employee may be found not meeting them or misbehaving deliberately, can be dismissed. So in this particular course, we looked at a number of issues. We mostly looked at the rights and obligations of both parties to the employment relationship. We looked at the dismissals on operational requirements and those on misconduct. We also looked at the various reasons an employer may terminate the contract of employment of an employee. Thank you.